Question 1. Governance review demonstrates that EnBW Energy is considering a strategic partnership with a new market entrant. This partnership could offer significant commercial advantages, but involves sharing sensitive operational data. What is the most appropriate course of action for EnBW Energy to ensure compliance with German energy market regulations and maintain market integrity? Option A. Proceed with the partnership, relying on the new entrant's assurances that they will adhere to all relevant market regulations. Option B. Initiate the partnership immediately to capitalize on the commercial opportunity, deferring a detailed regulatory assessment until after the deal is finalized. Option C. Seek informal advice from industry peers on similar partnerships to gauge general market acceptance. Option D. Conduct a comprehensive legal and compliance review of the proposed partnership against the Energiewirtschaftsgesetz (EnWG) and relevant EU regulations, documenting all findings and basing the decision on this analysis. The correct answer is D. Conduct a comprehensive legal and compliance review of the proposed partnership against the Energiewirtschaftsgesetz (EnWG) and relevant EU regulations, documenting all findings and basing the decision on this analysis. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential conflict between a company's strategic objectives and the stringent regulatory requirements governing energy market operations. EnBW Energy, as a significant player, must navigate these complexities to maintain compliance and stakeholder trust. The challenge lies in interpreting and applying specific regulatory provisions to a novel situation, ensuring that business decisions do not inadvertently lead to non-compliance or market manipulation. Careful judgment is required to balance commercial interests with the imperative of regulatory adherence. Correct approach analysis. The correct approach involves a thorough and documented assessment of the proposed strategic partnership against the specific provisions of the German Energy Industry Act, Energiewirtschaftsgesetz (EnWG), and relevant EU regulations, particularly those concerning market transparency and competition. This includes identifying any potential conflicts with rules on insider trading, market manipulation, and the obligation to provide objective and non-discriminatory access to infrastructure. The process should involve legal and compliance teams to ensure a robust interpretation and application of the law, leading to a formal decision based on this rigorous analysis. This approach is correct because it prioritizes regulatory compliance and due diligence, safeguarding EnBW Energy from legal repercussions and reputational damage. It demonstrates a commitment to ethical business practices and adherence to the rule of law, which are paramount in the regulated energy sector. Incorrect approaches analysis. An approach that prioritizes the immediate commercial benefits of the partnership without a comprehensive regulatory review is incorrect. This fails to acknowledge the significant legal and ethical obligations EnBW Energy has under the EnWG and EU energy market regulations. Such a decision would expose the company to substantial fines, regulatory sanctions, and severe reputational damage for potential breaches of market integrity rules. Another incorrect approach would be to seek informal assurances from the partner company regarding their compliance without independently verifying this through due diligence and legal scrutiny. This relies on assumptions rather than concrete evidence and regulatory assessment, which is insufficient to meet the standards of due diligence required in a regulated industry. It bypasses the necessary internal controls and risk assessment processes, proceeding with the partnership based on a general understanding of market practices, without a specific analysis of how the partnership aligns with the detailed requirements of the EnWG and related directives, is also professionally unacceptable. This demonstrates a lack of diligence and a failure to engage with the specific legal framework governing EnBW Energy's operations. Risks overlooking critical compliance issues that could have severe consequences. Professional reasoning. Professionals in this situation should adopt a structured decision-making process that begins with identifying the relevant regulatory framework. This is followed by a detailed analysis of how the proposed action, the strategic partnership, interacts with specific provisions of that framework. Engaging legal and compliance experts is crucial for accurate interpretation. The decision should be documented, with clear reasoning based on the regulatory assessment. If any doubt or ambiguity exists, seeking clarification from regulatory bodies or obtaining legal opinions should be considered. This systematic approach ensures that decisions are informed, compliant, and ethically sound, protecting both the company and the integrity of the energy market. Question 2. The monitoring system demonstrates an unusual fluctuation in the output of a critical generator at the EnBW Energy power plant. While the fluctuation is currently within the broader operational tolerance, it deviates from the expected stable performance parameters. What is the most appropriate immediate course of action for the EnBW Energy operations team? Option A. Directly report the fluctuation to the relevant regulatory authority as a potential operational deviation without conducting any internal verification or assessment. Option B. Immediately initiate a full system shutdown of the affected generator to prevent any potential escalation of the anomaly, regardless of the current operational tolerance. Option C. Initiate a detailed internal diagnostic review of the generator and associated systems, cross-referencing the observed fluctuation with historical data and relevant operational parameters, and consult EnBW's internal incident response protocols and applicable sections of the Energiewirtschaftsgesetz, (NWG), to determine if further action or reporting is required. Option D. Log the fluctuation as a minor anomaly and continue normal operations, assuming it will self-correct without further investigation. The correct answer is C. Initiate a detailed internal diagnostic review of the generator and associated systems, cross-referencing the observed fluctuation with historical data and relevant operational parameters, and consult EnBW's internal incident response protocols and applicable sections of the Energiewirtschaftsgesetz, (NWG), to determine if further action or reporting is required. Explanation. This scenario presents a professional challenge because it requires immediate and accurate interpretation of system alerts within the context of EnBW Energy's operational responsibilities and regulatory obligations. The core difficulty lies in distinguishing between a minor anomaly and a potential breach of operational safety or environmental standards, which necessitates a nuanced understanding of the relevant German energy regulations and EnBW's internal compliance protocols. The pressure to respond quickly without causing undue disruption, while simultaneously ensuring full compliance, demands a structured and informed decision-making process. The correct approach involves a systematic escalation and verification process. This begins with acknowledging the alert and initiating an immediate internal review to gather all available data related to the anomaly. This review should be conducted by appropriately qualified personnel who can assess the technical nature of the alert and its potential implications. If the initial assessment suggests a potential deviation from regulatory requirements or safety standards, the next step is to consult EnBW's specific operational guidelines and relevant sections of the German Energy Industry Act, Energiewirtschaftsgesetz (NWG), and associated ordinances, e.g., the Federal Emission Control Act Bundesemissionsschutzgesetz (BEMSG), if applicable to the nature of the alert. This consultation would determine the precise reporting obligations and required actions. Prompt and accurate reporting to the relevant regulatory authority, e.g., Bundesnetzagentur or a state-level environmental agency, is paramount if the anomaly indicates a potential breach. This approach ensures that EnBW Energy fulfills its legal duties, maintains operational integrity, and upholds its commitment to safety and environmental protection, aligning with the principles of due diligence and responsible energy provision mandated by German law. An incorrect approach would be to dismiss the alert without thorough investigation, assuming it is a false positive. This failure to investigate could lead to a significant regulatory breach if the anomaly is indeed indicative of a problem, resulting in potential fines, operational sanctions, and reputational damage. It directly contravenes the proactive monitoring and reporting requirements embedded within the NWG and environmental protection laws. Another incorrect approach would be to immediately shut down the affected system without a proper assessment. While seemingly cautious, this action, if not justified by an imminent and severe risk, could lead to unnecessary operational disruptions, supply interruptions, and potential economic losses. Furthermore, it might violate specific operational procedures outlined in EnBW's permits or regulatory approvals, which often mandate a phased response based on risk assessment. Such an action, taken without proper justification and reporting, could be viewed as an unauthorized operational change and a failure to adhere to prescribed protocols. A third incorrect approach would be to report the anomaly to the regulatory authority without conducting an initial internal verification. This could lead to unnecessary alarm and diversion of regulatory resources if the anomaly is found to be a minor, self-resolving issue. While transparency is crucial, an unverified report can strain the relationship with the regulator and indicate a lack of internal control and analytical capability, which is also a professional failing. The professional decision-making process for similar situations should involve a clear understanding of the company's operational context, the specific regulatory framework governing its activities, and established internal protocols for incident management. This includes 1. Immediate acknowledgement and data gathering, 2. Risk assessment by qualified personnel, 3. Consultation of relevant regulations and internal policies, 4. Appropriate escalation and reporting based on the assessment, and 5. Documentation of all actions taken. This structured approach ensures that decisions are informed, compliant, and proportionate to the identified risks. Question 3. Market research demonstrates that EnBW Energy is observing a significant, albeit preliminary, shift in regional energy demand patterns that could impact future pricing. Considering the regulatory framework governing energy markets in Germany and the EU, which of the following actions best reflects a compliant and professionally responsible approach for EnBW Energy to take? Option A. Immediately adjust EnBW Energy's trading positions based on the preliminary demand shift to capitalize on anticipated price movements, without further internal consultation. Option B. Share the preliminary market research findings with key industry contacts outside of EnBW Energy to gauge their reactions and potential market implications. Option C. Conduct a thorough internal review of the preliminary market research findings, assess their potential impact on market integrity, and consult with EnBW Energy's compliance department to determine appropriate next steps for strategic planning and potential disclosure. Option D. Disregard the preliminary market research findings, as they are not yet conclusive enough to warrant immediate strategic action or trading adjustments. The correct answer is A. Immediately adjust EnBW Energy's trading positions based on the preliminary demand shift to capitalize on anticipated price movements, without further internal consultation. Explanation. This scenario presents a professional challenge because EnBW Energy, as a participant in the energy market, must navigate complex regulatory requirements related to market transparency and fair competition. The challenge lies in balancing the need for internal strategic planning with the legal and ethical obligations to avoid market manipulation or the misuse of sensitive information. Careful judgment is required to ensure that EnBW's actions are compliant with the relevant regulatory framework, specifically the German Energy Industry Act, Energiegesetz (EnWG), and associated ordinances, as well as EU regulations like REMIT, Regulation on Wholesale Energy Market Integrity and Transparency. The correct approach involves EnBW Energy establishing and adhering to strict internal protocols for handling and disseminating sensitive market information. This includes clearly defining what constitutes inside information, implementing robust access controls, and ensuring that any communication or analysis of such information is conducted in a manner that does not lead to market manipulation or insider trading. Specifically, EnBW must ensure that any market research findings are analyzed and acted upon in a way that respects the principles of fair competition and market integrity, as mandated by the EnWG and REMIT. This approach is professionally sound because it directly aligns with the regulatory imperative to prevent market abuse and maintain a level playing field for all market participants. It demonstrates a commitment to ethical conduct and regulatory compliance, safeguarding both EnBW's reputation and the integrity of the energy market. An incorrect approach would be to use the preliminary findings of market research, which indicate potential shifts in energy demand, to inform immediate trading strategies without proper internal review or consideration of whether this information constitutes inside information. This is a regulatory failure because it risks violating provisions against market manipulation and insider trading, as defined by the EnWG and REMIT. Such actions could lead to significant penalties and reputational damage. Another incorrect approach would be to share these preliminary market research findings with external parties, such as industry analysts or other companies, before they are publicly disclosed or properly vetted. This constitutes a breach of confidentiality and could be construed as an attempt to unfairly influence market behavior or provide an unfair advantage to those receiving the information, thereby violating the principles of market integrity and transparency. A third incorrect approach would be to dismiss the market research findings entirely due to a lack of immediate actionable trading insights, without considering their broader implications for strategic planning or potential future market developments. While not directly a violation of market abuse rules, this represents a failure in professional due diligence and strategic foresight, potentially leading to missed opportunities and a competitive disadvantage for EnBW Energy. The professional decision-making process for similar situations should involve a multi-step approach. First, identify the nature of the information obtained through market research. Is it publicly available, or does it potentially constitute inside information? Second, consult internal compliance policies and legal counsel to determine the appropriate handling and dissemination procedures for such information, especially if it is deemed sensitive. Third, ensure that any strategic decisions or actions taken based on this information are fully compliant with all relevant regulations, prioritizing market integrity and fair competition. Finally, maintain thorough documentation of all processes and decisions to demonstrate compliance. Question 4. Quality control measures reveal that the energy generation data recorded by EnBW Energy's primary generation facility for the past quarter contains significant discrepancies when compared to independent meter readings. These discrepancies directly impact the reported energy output, and consequently, the revenue figures used in both internal reporting and regulatory submissions. What is the most appropriate course of action for EnBW Energy to take? Option A. Immediately adjust the reported revenue figures to align with the independent meter readings and initiate a detailed internal audit to identify the cause of the data recording errors. Option B. Inform the relevant regulatory bodies of the potential discrepancies and request an extension for the current reporting period while a full investigation is conducted. Option C. Instruct the generation facility's operational staff to manually correct the internal data logs to match the independent meter readings without further investigation or external reporting. Option D. Proceed with the existing reported figures, assuming the internal recording system is generally reliable, and address any minor discrepancies during the next annual audit. The correct answer is A. Immediately adjust the reported revenue figures to align with the independent meter readings and initiate a detailed internal audit to identify the cause of the data recording errors. Explanation: this scenario is professionally challenging because it requires EnBW Energy to navigate a complex interplay between internal operational efficiency, regulatory compliance, and the ethical imperative to maintain accurate and transparent financial reporting. The discovery of discrepancies in energy generation data, which directly impacts reported revenue and potentially regulatory filings, necessitates a swift and principled response. The core challenge lies in balancing the need for immediate corrective action with the requirement to conduct a thorough, unbiased investigation that upholds EnBW Energy's commitment to regulatory adherence and stakeholder trust. The correct approach involves a systematic and documented investigation into the root cause of the data discrepancies. This includes engaging relevant internal departments, e.g., operations, IT, finance, and potentially external experts if necessary. The focus must be on identifying the precise nature of the error, its impact on reported figures, and implementing robust corrective measures to prevent recurrence. Crucially, this process must be conducted with full transparency to relevant regulatory bodies, adhering to all reporting timelines and disclosure requirements. This upholds the principle of regulatory compliance by ensuring that any inaccuracies are identified, rectified, and reported in accordance with applicable laws and guidelines governing energy market operations and financial reporting. It also aligns with ethical obligations to maintain data integrity and provide accurate information to stakeholders. An incorrect approach that prioritizes immediate financial adjustments without a thorough investigation risks masking underlying systemic issues, potentially leading to further inaccuracies and regulatory penalties. This approach fails to address the root cause, leaving EnBW Energy vulnerable to repeated errors and a loss of credibility. Another incorrect approach, such as attempting to conceal the discrepancies or downplaying their significance, constitutes a direct violation of regulatory disclosure requirements and ethical standards. Such actions undermine the integrity of financial reporting and could lead to severe legal and reputational consequences. Furthermore, an approach that delays reporting or corrective actions beyond stipulated regulatory timelines would also be a failure, as it demonstrates a lack of diligence and respect for the established legal and operational frameworks. Professionals should employ a decision-making framework that prioritizes a structured, evidence-based approach. This involves 1. Immediate containment and assessment of the issue's scope. 2. Initiating a formal, documented investigation with clear lines of responsibility. 3. Consulting relevant internal policies and external regulatory guidance. 4. Engaging with legal and compliance departments to ensure adherence to all reporting obligations. And 5. Implementing sustainable corrective actions and controls. This systematic process ensures that decisions are informed, compliant, and ethically sound, fostering a culture of accountability and transparency within EnBW Energie. Question 5. Quality control measures reveal a discrepancy in the reported energy generation figures for a key EnBW Energie power plant for the previous reporting period. While the internal system shows a lower output, the data submitted to the relevant German energy market regulator indicates a higher, more favorable figure, potentially due to an error in the automated data aggregation process. Option A. Submit a new report with the corrected figures but do not include any explanation, as this might draw undue attention to the error. Option B. Immediately investigate the cause of the discrepancy, correct the internal records, and submit a revised, accurate report to the regulator with an explanation of the error and corrective actions. Option C. Adjust the internal records to match the previously submitted figure to avoid any appearance of inconsistency, assuming the submitted figure was likely closer to the actual output. Option D. Wait for the regulator to identify the discrepancy during their review and then provide an explanation, hoping it will be viewed as a minor oversight. The correct answer is B. Immediately investigate the cause of the discrepancy, correct the internal records, and submit a revised, accurate report to the regulator with an explanation of the error and corrective actions. Explanation. This scenario is professionally challenging because it requires EnBW Energie to navigate potential conflicts between operational efficiency and regulatory compliance, specifically concerning the reporting of energy generation data. The pressure to meet internal targets or external demands for timely information must be balanced against the absolute requirement for accuracy and adherence to the regulatory framework governing energy markets. Misreporting can lead to significant penalties, reputational damage, and erosion of market trust. The correct approach involves immediately initiating a thorough internal investigation to identify the root cause of the discrepancy, and then reporting the corrected data to the relevant regulatory body as soon as possible, along with a clear explanation of the error and the steps taken to prevent recurrence. This demonstrates transparency, accountability, and a commitment to regulatory integrity, which are paramount in the energy sector. Adherence to the specific reporting requirements and timelines mandated by the relevant German energy market regulations, e.g., those overseen by the Bundesnetzagentur, is crucial. An incorrect approach of attempting to correct the data internally without notifying the regulator, or worse, submitting revised data that still doesn't fully reflect the reality, would constitute a serious breach of regulatory obligations. This could be interpreted as an attempt to mislead the regulator, leading to severe sanctions. Another incorrect approach would be to delay reporting the corrected data beyond the stipulated regulatory deadlines, even if the intention is to ensure accuracy. This failure to adhere to reporting timelines, regardless of the reason, is a direct violation of regulatory requirements and undermines the integrity of market data. Professionals in this situation should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Immediate identification and assessment of the discrepancy. 2. Consultation with internal compliance and legal teams. 3. Prompt and transparent communication with the regulatory authority. And 4. Implementation of robust internal controls to prevent future occurrences. The guiding principle should always be adherence to the letter and spirit of the applicable regulations. Question 6. The performance metrics show a consistent deviation in the energy distribution efficiency for a specific region served by EnBW Energie. While the deviation is not yet at a level that triggers automatic penalties, It suggests a potential underperformance that could, if unaddressed, lead to future noncompliance with established energy market regulations. What is the most appropriate immediate course of action for EnBW Energy? Option A. Implement minor internal adjustments to the distribution network to try and correct the deviation without notifying the regulatory authority, assuming the issue is minor. Option B. Focus solely on improving other performance metrics to offset the impact of this deviation in overall reporting, without directly addressing the specific regional distribution efficiency issue. Option C. Immediately report the observed deviation to the relevant energy regulatory authority and initiate an internal investigation to understand the root cause and develop a remediation plan. Option D. Continue current operations, monitor the deviation closely, and only take action if it escalates to a level that triggers formal regulatory warnings or penalties. Correct answer is C. Immediately report the observed deviation to the relevant energy regulatory authority and initiate an internal investigation to understand the root cause and develop a remediation plan. Explanation: this scenario is professionally challenging because it requires EnBW Energy to balance the immediate need for operational efficiency with its long-term regulatory obligations and ethical responsibilities. The pressure to meet performance targets can create a temptation to overlook or downplay potential compliance issues. Careful judgment is required to ensure that any actions taken are not only effective in the short term, but also sustainable and compliant with the relevant regulatory framework. The correct approach involves a proactive and transparent engagement with the regulatory body. This demonstrates a commitment to compliance and allows for a collaborative resolution. By immediately reporting the potential noncompliance and seeking guidance, EnBW Energy signals its good faith and willingness to rectify any issues. This aligns with the principles of regulatory oversight, which often prioritize cooperation and timely disclosure to mitigate harm and ensure market integrity. Specifically, this approach upholds the spirit of regulations designed to ensure fair competition and consumer protection by addressing potential breaches head-on. An incorrect approach that involves attempting to rectify the issue internally without informing the regulator risks exacerbating the problem. If the internal fix is insufficient, or if the issue is discovered later, it could lead to more severe penalties and reputational damage. This failure to disclose is a direct contravention of regulatory expectations for transparency and can be interpreted as an attempt to conceal a breach. Another incorrect approach, which is to ignore the potential issue and continue with current practices, is ethically and regulatorily unacceptable. This demonstrates a disregard for compliance obligations and could lead to ongoing harm to the market or consumers, depending on the nature of the performance metric. It also exposes EnBW Energy to significant legal and financial repercussions once the noncompliance is identified. The professional decision-making process for similar situations should involve a structured assessment of any identified performance deviations. This includes 1. Understanding the nature and potential impact of the deviation. 2. Consulting the relevant regulatory framework and internal compliance policies. 3. Assessing whether the deviation constitutes a potential breach of regulations. 4. If a potential breach is identified, immediately engaging with the compliance department and legal counsel. 5. Determining the appropriate course of action, which may include self-reporting to the regulatory authority and developing a remediation plan. Transparency, integrity, and adherence to the regulatory framework should guide every step. Question 7. The control framework reveals a potential weakness in EnBW Energy's data handling procedures concerning the anonymization of customer energy consumption data before it is used for market trend analysis. This anonymization process is critical for complying with data privacy regulations. A project manager, under pressure to deliver timely market insights, is considering bypassing the anonymization step for a specific, time-sensitive analysis, arguing that the data is for internal use only and the risk is minimal. What is the most appropriate course of action for the project manager to take? Option A. Share the unanonymized data with a trusted internal analytics team for a preliminary review, with strict instructions to avoid any further dissemination or analysis beyond the initial scope. Option B. Halt the market trend analysis until the anonymization process is fully reviewed and confirmed to be robust, or an approved alternative method for data handling is established in compliance with regulations. Option C. Immediately implement the market trend analysis using the anonymized data, and then initiate a formal review of the anonymization process to identify potential improvements. Option D. Proceed with the analysis using the unanonymized data, documenting the decision and the perceived minimal risk, and inform the data protection officer after the analysis is complete. The correct answer is C. Immediately implement the market trend analysis using the anonymized data, and then initiate a formal review of the anonymization process to identify potential improvements. Explanation: this scenario presents a professional challenge due to the inherent conflict between achieving business objectives and adhering to stringent regulatory requirements concerning data privacy and security. EnBW Energy, as a company operating within a regulated energy sector, must prioritize compliance to maintain trust, avoid penalties, and protect sensitive customer information. The difficulty lies in balancing the need for operational efficiency and data utilization with the legal obligations to safeguard data. Careful judgment is required to ensure that any data processing activities are conducted ethically and in full accordance with the specified regulatory framework. Correct approach involves a thorough review and understanding of the EnBW Energy's internal data handling policies, which are designed to align with the relevant regulatory framework. This approach prioritizes a systematic and compliant method for addressing the identified control weakness. Specifically, it requires documenting the issue, assessing its impact, and developing a remediation plan that adheres to all legal and ethical standards for data protection. This ensures that EnBW Energy not only rectifies the control deficiency, but does so in a manner that upholds its regulatory obligations and protects customer data. An incorrect approach that involves immediately sharing the sensitive data with external parties without proper authorization or anonymization would represent a significant regulatory and ethical failure. This action directly contravenes data protection laws, potentially leading to severe penalties, reputational damage, and a breach of customer trust. Another incorrect approach, such as ignoring the control weakness due to perceived urgency of business needs, demonstrates a disregard for compliance and a failure to uphold professional responsibility. This can lead to systemic vulnerabilities and future breaches. Finally, an approach that involves a superficial fix without addressing the root cause of the control deficiency would also be professionally unacceptable, as it fails to provide lasting security and compliance. Professionals should employ a decision-making framework that begins with identifying and understanding the regulatory landscape. When a control weakness is identified, the process should involve a risk assessment, followed by the development and implementation of a remediation plan that is compliant with all applicable laws and ethical guidelines. This framework emphasizes proactive risk management and a commitment to maintaining the highest standards of data integrity and privacy. Question 8. Strategic planning requires EnBW Energy to consider its expansion into new renewable energy trading markets. Which of the following approaches best aligns with the absolute priority of adhering to the regulatory framework, laws, and guidelines applicable to energy trading in Germany? Option A. Conduct a comprehensive pre-implementation review of all relevant German energy market regulations, including the Energiewirtschaftsgesetz, NWG, and Bundesnetzagentur, BNetzA, guidelines, to ensure full compliance before launching any new trading strategies. Option B. Seek to identify and exploit any ambiguities or less enforced aspects of current regulations to gain a competitive edge, with the understanding that such practices are common in dynamic markets. Option C. Focus on leveraging existing market knowledge and competitor strategies, with a secondary consideration for regulatory compliance only if explicitly flagged as a significant risk by the legal department. Option D. Prioritize market share acquisition and revenue growth, assuming that any minor regulatory deviations will be addressed through post-implementation adjustments and potential fines, which are factored into the business case. The correct answer is D. Prioritize market share acquisition and revenue growth, assuming that any minor regulatory deviations will be addressed through post-implementation adjustments and potential fines, which are factored into the business case. Explanation: this scenario presents a professional challenge for EnBW Energy employees by requiring them to navigate the complex interplay between strategic business objectives and the stringent regulatory framework governing energy markets in Germany. The core difficulty lies in balancing the company's desire for competitive advantage and market expansion with the absolute priority of adhering to all applicable laws and regulations, particularly those related to energy trading and market conduct. Misinterpreting or circumventing these regulations, even with the intention of achieving strategic goals, can lead to severe penalties, reputational damage, and erosion of market trust. Careful judgment is required to ensure that all strategic initiatives are not only commercially sound, but also fully compliant. The correct approach involves a proactive and thorough regulatory compliance review integrated into the strategic planning process. This means that before any new market strategy is finalized or implemented, EnBW Energy must conduct a comprehensive assessment to identify all relevant legal and regulatory requirements. This includes understanding the specific provisions of the German Energy Industry Act, Energiewirtschaftsgesetz (EnBW), the German Energy Network Regulatory Office, Bundesnetzagentur B-Netz A guidelines, and any relevant EU regulations that have direct applicability. The justification for this approach rests on the fundamental principle of regulatory adherence, which is paramount in the energy sector. It ensures that EnBW Energy operates within the legal boundaries, avoids sanctions, and maintains its license to operate. Ethical considerations also demand transparency and fair competition, which are underpinned by strict regulatory compliance. An incorrect approach that prioritizes immediate commercial gains over regulatory scrutiny would be professionally unacceptable. This failure stems from a disregard for the legal framework, potentially leading to violations of market rules, insider trading prohibitions, or unfair competitive practices. Such actions directly contravene the EnBW and B-Netza directives, which are designed to ensure market integrity and consumer protection. Another incorrect approach, which involves seeking loopholes or ambiguities in regulations to gain an advantage, is also ethically and legally flawed. While not an outright violation, it undermines the spirit of the law and can lead to unintended consequences or future regulatory tightening. This approach demonstrates a lack of due diligence and a willingness to operate in a gray area, which is contrary to the professional responsibility of upholding the integrity of the energy market. The professional decision-making process for similar situations should involve a structured risk assessment framework. This framework should mandate that all strategic proposals undergo a rigorous compliance check by legal and regulatory experts within EnBW Energy. If any potential conflicts or ambiguities arise, the strategy should be revised or halted until full clarity and compliance are achieved. Professionals should always err on the side of caution and prioritize adherence to the letter and spirit of the law, recognizing that long-term business success is inextricably linked to sustainable and compliant operations. Question 9. Quality control measures reveal that certain customer data collected by EnBW Energy for billing purposes may be inadvertently used for marketing analytics without explicit consent, potentially contravening data protection regulations. Which of the following actions should EnBW Energy prioritize to address this issue? Option A. Continue current data processing practices for marketing analytics, assuming that the broad terms of service cover such usage, and await further clarification from regulatory bodies. Option B. Immediately cease all marketing analytics activities that utilize billing data and conduct a comprehensive review of consent mechanisms and data usage policies to ensure alignment with regulatory requirements. Option C. Inform customers that their billing data may have been used for marketing analytics and seek to obtain retrospective consent for past and future usage. Option D. Delete all customer billing data that has been used for marketing analytics to mitigate any potential regulatory violations, regardless of the impact on business operations. Correct answer is B. Immediately cease all marketing analytics activities that utilize billing data and conduct a comprehensive review of consent mechanisms and data usage policies to ensure alignment with regulatory requirements. Explanation. This scenario presents a professional challenge due to the potential for misinterpreting and misapplying regulatory requirements concerning the handling of sensitive customer data within EnBW Energy. The core difficulty lies in balancing operational efficiency with the stringent data protection obligations mandated by relevant regulations. A failure to adhere to these regulations can lead to significant financial penalties, reputational damage, and a loss of customer trust. Careful judgment is required to ensure that all data handling practices are compliant, transparent, and secure. The correct approach involves a thorough review of EnBW Energy's internal data processing policies against the specific requirements of the applicable regulatory framework. This includes identifying the exact nature of the data collected, the purposes for which it is used, and the consent mechanisms in place. The regulatory framework likely mandates specific procedures for data minimization, purpose limitation, and secure storage, as well as clear guidelines on data subject rights. Adhering to these principles ensures that EnBW Energy operates within legal boundaries and upholds ethical standards in data management. An incorrect approach that involves immediately deleting all potentially sensitive data without a proper assessment risks disrupting essential business operations and may violate regulations that permit data processing under specific lawful bases, provided appropriate safeguards are in place. This approach fails to acknowledge the nuances of data protection laws, which often allow for data processing when justified and secured. Another incorrect approach, which is to continue processing the data as before while assuming compliance, is professionally unacceptable because it ignores the findings of the quality control measures. This demonstrates a disregard for internal audit findings and a failure to proactively address potential regulatory breaches. It assumes a level of compliance that has been called into question, thereby increasing the risk of ongoing noncompliance. A further incorrect approach, such as seeking external legal advice only after a significant breach has occurred, is reactive rather than proactive. While legal advice is crucial, delaying its engagement until after a problem is identified misses the opportunity to implement preventative measures and robust compliance frameworks, which is a key expectation under regulatory oversight. The professional decision-making process for similar situations should involve a structured approach. 1. Acknowledge and investigate the quality control findings immediately. 2. Conduct a comprehensive internal review of data handling practices against the specific regulatory framework. 3. Consult with legal and compliance experts to interpret regulatory requirements and assess current practices. 4. Develop and implement corrective actions based on the review and expert advice. 5. Establish ongoing monitoring and auditing mechanisms to ensure sustained compliance. 6. Prioritize transparency with relevant stakeholders, including customers, where appropriate and legally permissible. Question 10. Quality control measures reveal inconsistencies in the data used by EnBW Energy for its quarterly performance reporting, specifically concerning the recorded output from a key renewable energy generation facility. The discrepancies appear to stem from a recent software update to the facility's monitoring system. Which of the following actions should EnBW Energy prioritize to address this situation? Option A. Proceed with the current reporting cycle using the existing data, assuming the discrepancies are minor and will not significantly impact the overall performance metrics, and address the issue in the subsequent quarter. Option B. Instruct the external IT vendor responsible for the software update to revert the system to its previous version without further internal investigation. Option C. Immediately initiate a comprehensive audit of the data collection and processing procedures related to the affected facility, involving both operational and IT teams, to identify the root cause of the inconsistencies and implement necessary corrections before the next reporting cycle. Option D. Discard all data from the affected facility for the current reporting period and report based on historical averages to avoid potential inaccuracies. The correct answer is C. Immediately initiate a comprehensive audit of the data collection and processing procedures related to the affected facility, involving both operational and IT teams, to identify the root cause of the inconsistencies and implement necessary corrections before the next reporting cycle. Explanation: this scenario presents a professional challenge because it requires EnBW Energy to navigate potential conflicts between operational efficiency and regulatory compliance, specifically concerning data handling and reporting. The core difficulty lies in ensuring that the data used for internal performance monitoring is accurate, complete, and adheres to the strict reporting standards mandated by relevant energy market regulations. A failure to do so could lead to misinformed strategic decisions, regulatory penalties, and reputational damage. The correct approach involves a thorough investigation into the data discrepancies, focusing on identifying the root cause of the errors, and implementing corrective actions that align with EnBW Energy's internal policies and external regulatory obligations. This proactive and systematic method ensures that data integrity is maintained, thereby supporting accurate reporting and compliant operations. The regulatory justification stems from the fundamental requirement for energy companies to maintain accurate records and provide reliable data to regulatory bodies. Adherence to these standards is not merely a procedural step, but a cornerstone of market integrity and consumer protection. An incorrect approach of immediately discarding the suspect data without understanding its origin is professionally unacceptable. This bypasses the opportunity to identify systemic issues within EnBW Energy's data collection or processing systems, potentially leading to recurring errors. Ethically, it represents a failure to exercise due diligence in managing critical operational data. Another incorrect approach of proceeding with the analysis using the potentially flawed data, assuming the discrepancies are minor, is also professionally unsound. This risks generating inaccurate performance metrics and misleading internal stakeholders. It violates the principle of data integrity and could lead to non-compliance with reporting requirements, exposing EnBW Energy to regulatory scrutiny and sanctions. A further incorrect approach of solely relying on external IT support to rectify the data without internal validation and understanding of the business context fails to acknowledge the shared responsibility for data quality. While IT support is crucial for technical solutions, the business units are responsible for the accuracy and meaning of the data they generate and use. This approach risks implementing a fix that doesn't address the underlying business process issue or fully meet regulatory nuances. The professional decision-making process for similar situations should involve a structured approach. First, acknowledge and document the discrepancy. Second, initiate an investigation to determine the root cause, involving relevant internal departments, e.g., operations, IT, compliance. Third, assess the impact of the discrepancy on reporting and decision-making. Fourth, implement corrective actions, which may include data cleansing, process improvements, or system enhancements. Finally, validate the corrective actions and establish ongoing monitoring to prevent recurrence. This methodical process ensures that EnBW Energy maintains data integrity, meets regulatory obligations, and makes informed business decisions. Question 11. Quality control measures reveal that EnBW Energy's IT department has developed a new, highly efficient data processing system designed to streamline reporting to regulatory bodies. However, initial internal checks suggest that the system's data anonymization protocols may not fully align with the specific requirements stipulated by the German Federal Network Agency, Bundesnetzagentur, for market data transparency. The IT department is eager to deploy the system to realize immediate efficiency gains. What is the most appropriate course of action for EnBW Energy to take in this situation? Option A. Immediately deploy the new system and address any potential regulatory discrepancies with the Bundesnetzagentur after deployment. Option B. Prioritize the efficiency gains by deploying the system and instruct the IT department to retroactively adjust the anonymization protocols if any issues are flagged by the Bundesnetzagentur in the future. Option C. Halt the deployment of the new system and conduct a thorough review of its data anonymization protocols in consultation with the compliance department and legal counsel to ensure full adherence to Bundesnetzagentur regulations before any further action. Option D. Proceed with the deployment, relying on the vendor's assurances that the system meets all relevant data processing standards, and inform the Bundesnetzagentur of the potential minor deviations only if they become apparent during audits. The correct answer is A. Immediately deploy the new system and address any potential regulatory discrepancies with the Bundesnetzagentur after deployment. Explanation. This scenario presents a professional challenge because it requires EnBW Energy to navigate potential conflicts between internal operational efficiency and external regulatory compliance, specifically concerning data handling and reporting. The core difficulty lies in ensuring that the pursuit of streamlined processes does not inadvertently lead to breaches of regulatory requirements, which could result in significant penalties, reputational damage, and loss of stakeholder trust. Careful judgment is required to balance the benefits of technological adoption with the imperative of adhering to established legal and ethical standards. The correct approach involves a proactive and thorough review of the new data processing system against the specific requirements of the relevant German energy market regulations and EnBW Energy's internal compliance policies. This approach is best professional practice because it prioritizes regulatory adherence and data integrity. By engaging with the compliance department and conducting a detailed assessment, EnBW Energy demonstrates a commitment to operating within the legal framework, safeguarding sensitive data, and ensuring the accuracy and reliability of its reporting. This aligns with the principles of due diligence and responsible corporate governance expected within the German energy sector. An incorrect approach of immediately implementing the new system without a comprehensive regulatory review poses significant risks. This failure to conduct due diligence could lead to non-compliance with data protection laws, e.g., GDPR, as applicable in Germany, and specific energy market regulations regarding data retention, reporting formats, or access controls. Such non-compliance could result in substantial fines, regulatory sanctions, and damage to EnBW Energy's reputation. Another incorrect approach of relying solely on the vendor's assurance of compliance is also professionally unacceptable. While vendors may provide assurances, the ultimate responsibility for regulatory compliance rests with EnBW Energy. Delegating this critical oversight function without independent verification exposes the company to undue risk. This demonstrates a lack of internal control and a failure to exercise the necessary professional skepticism. A further incorrect approach of delaying the review due to perceived time constraints, while understandable from an operational perspective, is ethically and legally flawed. Regulatory compliance is not a secondary consideration that can be deferred. Prioritizing immediate operational gains over mandatory legal obligations is a direct violation of professional responsibility and can lead to more severe consequences if non-compliance is discovered later. The professional decision-making process for similar situations should involve a structured risk assessment framework. This framework should include 1. Identifying all relevant regulatory obligations and internal policies. 2. Assessing the potential impact of any proposed change, e.g., new technology process modification on compliance. 3. Engaging relevant internal stakeholders, including legal, compliance, and IT departments early in the process. 4. Conducting thorough testing and validation against regulatory requirements. 5. Documenting all compliance assessments and decisions. 6. Establishing clear escalation paths for identified compliance risks. Question 12. System analysis indicates that the head of department at EnBW Energy has instructed a junior analyst to prioritize securing a new client contract by offering preferential pricing that appears to deviate significantly from standard market rates, potentially creating an unfair competitive advantage. The junior analyst suspects this directive might contravene German energy market regulations concerning fair competition and anti-collusion. What is the most appropriate course of action for the junior analyst? Option A. Immediately refuse to implement the directive, citing personal concerns about potential regulatory breaches without further consultation. Option B. Ignore the directive and continue with standard pricing models without informing the head of department or seeking clarification. Option C. Proceed with the directive as instructed by the head of department to secure the contract, assuming the department head has considered all regulatory implications. Option D. Escalate the concerns regarding the preferential pricing to EnBW Energy's compliance or legal department for review and guidance before proceeding. Correct answer is C. Proceed with the directive as instructed by the head of department to secure the contract, assuming the department head has considered all regulatory implications. Explanation. This scenario presents a professional challenge for an employee at EnBW Energy due to the potential conflict between internal company directives and external regulatory requirements. The core difficulty lies in navigating situations where a direct order from a superior might inadvertently lead to a breach of established legal or ethical standards governing the energy sector. Careful judgment is required to ensure that all actions taken by EnBW Energy employees align with the applicable regulatory framework, thereby safeguarding the company's reputation, avoiding legal penalties, and upholding ethical business practices. The correct approach involves prioritizing adherence to the regulatory framework over a potentially conflicting internal directive. This is because regulatory compliance is paramount in the energy sector, ensuring market integrity, consumer protection, and environmental standards. Specifically, If the internal directive from the head of department at EnBW Energy appears to contravene the principles of fair competition or data privacy as stipulated by relevant German energy market regulations, e.g., Energiewirtschaftsgesetz NWG or GDPR as applicable to data handling, the employee must escalate the issue. This escalation should follow established internal whistleblowing or compliance channels, or directly involve the company's legal or compliance department to seek clarification and ensure the directive is either amended or demonstrably compliant. This upholds the principle of lawful conduct and demonstrates a commitment to ethical operations, which is a fundamental expectation for employees in regulated industries. An incorrect approach would be to blindly follow the head of department's directive without questioning its regulatory implications. This failure to scrutinize the directive against the established legal framework constitutes a significant ethical and regulatory lapse. It could expose EnBW Energy to fines, sanctions, and reputational damage. Another incorrect approach would be to ignore the directive and take no action, neither complying nor escalating. This passive stance fails to address the potential regulatory breach and leaves the company vulnerable. Finally, an incorrect approach would be to directly refuse the directive without attempting to understand its regulatory context or seeking internal guidance. While the intent might be to avoid regulatory breach, this could be perceived as insubordination and might not be the most effective way to resolve the conflict, as it bypasses established internal processes for addressing such issues. The professional reasoning process for similar situations should involve a structured approach. First, thoroughly understand the directive and its potential implications. Second, cross-reference the directive with the relevant regulatory framework and internal company policies. Third, if a conflict or ambiguity is identified, immediately consult with the company's compliance or legal department, or utilize designated internal reporting channels. Fourth, document all communications and actions taken. This systematic process ensures that decisions are informed, compliant, and ethically sound, protecting both the individual employee and EnBW Energy. Question 13. Benchmark analysis indicates that EnBW Energy's current internal reporting process for customer energy consumption data used for performance benchmarking may not fully align with the stringent data protection requirements stipulated by German federal law and relevant EU regulations. Specifically, there is a concern that certain aggregated data points, while not directly identifiable, could potentially be re-identified through cross-referencing with other available datasets within the company. This situation requires a decision on how to proceed with the reporting to ensure both operational insight and legal compliance. Option A. Immediately halt all internal reporting of customer energy consumption data until a comprehensive legal review can be conducted to ensure full compliance with all applicable German and EU data protection laws, even if this significantly delays benchmark analysis. Option B. Continue with the current reporting process, assuming that internal aggregation sufficiently anonymizes the data and that the primary purpose is internal operational improvement, which is a legitimate business interest. Option C. Implement a revised reporting protocol that includes robust anonymization techniques and data minimization principles, ensuring that only the minimum necessary data is reported for benchmarking purposes, and document this process thoroughly for compliance verification. Option D. Rely on the existing internal data governance policies of EnBW Energy, which are designed to protect sensitive information, and proceed with the current reporting method, assuming these policies are sufficient to meet external legal obligations. The correct answer is B. Continue with the current reporting process, assuming that internal aggregation sufficiently anonymizes the data and that the primary purpose is internal operational improvement, which is a legitimate business interest. Explanation. This scenario presents a professional challenge for an employee at EnBW Energy due to the need to balance internal company directives with external regulatory compliance, specifically concerning data handling and reporting. The core of the challenge lies in interpreting and applying the relevant German regulatory framework, likely the GDPR, General Data Protection Regulation, as it applies to data processing and reporting within the energy sector in Germany, and potentially specific German energy market regulations. Careful judgment is required to ensure that EnBW Energy's reporting practices are both efficient for internal analysis and fully compliant with legal obligations, avoiding potential penalties or reputational damage. The correct approach involves a thorough understanding of the applicable German data protection laws and energy market regulations. This means ensuring that any data shared internally for benchmark analysis is anonymized or pseudonymized to the extent required by law, and that the reporting mechanisms themselves adhere to any specific disclosure or reporting standards mandated by German energy regulators. This approach upholds legal and ethical standards by prioritizing data privacy and regulatory adherence, thereby protecting both the company and individuals whose data might be involved. An incorrect approach would be to proceed with internal reporting without adequately considering the legal implications of the data being processed. For instance, sharing raw, identifiable customer data internally for benchmarking purposes, without proper anonymization or a clear legal basis, would likely violate GDPR principles regarding data minimization and purpose limitation. Another incorrect approach would be to assume that internal company policy automatically supersedes external regulatory requirements. This demonstrates a failure to recognize the primacy of law over internal guidelines and could lead to noncompliance. A third incorrect approach might involve delaying the implementation of compliant reporting mechanisms due to perceived internal complexity, thereby risking ongoing regulatory breaches. Professionals should employ a decision-making framework that prioritizes regulatory compliance. This involves proactively identifying all relevant legal and regulatory obligations, seeking expert advice, legal or compliance departments, when in doubt, and ensuring that internal processes are designed to meet these external standards. A risk-based approach, assessing potential consequences of noncompliance, is also crucial. When faced with conflicting internal and external requirements, the legally mandated standard must always take precedence. Question 14. Quality control measures reveal that for the past quarter, the reported energy generation data for a key EnBW energy power plant shows consistent, albeit minor, discrepancies compared to real-time operational logs. The discrepancies appear to stem from an updated software module introduced for automated data aggregation. Which of the following actions should EnBW Energy prioritize in response to these findings? Option A. Inform the BNets about the potential for minor data discrepancies due to the new software, but delay any internal investigation or correction until the BNets requests clarification. Option B. Focus solely on rectifying the software issue internally to prevent future discrepancies, without informing the BNets as the reported data has not been intentionally falsified. Option C. Continue reporting the data as generated by the new software, assuming the discrepancies are minor and unlikely to be detected by the BNets while planning to address them in the next reporting cycle. Option D. Immediately initiate a comprehensive internal audit to identify the exact cause of the data discrepancies, rectify any identified errors in the aggregation software, and then proactively report the findings and corrective actions taken to the Bundesnetzagentur, BNets. Correct answer is D. Immediately initiate a comprehensive internal audit to identify the exact cause of the data discrepancies, rectify any identified errors in the aggregation software, and then proactively report the findings and corrective actions taken to the Bundesnetzagentur, BNets. Explanation. This scenario presents a professional challenge because it requires EnBW Energy to navigate potential conflicts between operational efficiency and regulatory compliance, specifically concerning the reporting of energy generation data. The core difficulty lies in ensuring the accuracy and integrity of data submitted to regulatory bodies, which forms the basis for market oversight, policy decisions, and potentially financial settlements. A failure in this area can lead to significant penalties, reputational damage, and a loss of trust from regulators and market participants. The correct approach involves a thorough investigation into the root cause of the discrepancies, followed by a proactive and transparent communication with the relevant regulatory authority. This demonstrates a commitment to compliance and data integrity, which are paramount in the energy sector. Specifically, the approach of immediately initiating a detailed internal review to identify the source of the data anomalies, rectifying any identified errors, and then reporting the findings and corrective actions to the Bundesnetzagentur, BNets, aligns with the principles of good corporate governance and regulatory adherence expected under German energy law and BNets guidelines. This proactive disclosure and remediation are crucial for maintaining a good standing with the regulator. An incorrect approach would be to ignore the discrepancies or to attempt to correct them without informing the regulator. This failure to disclose potential inaccuracies, even if unintentional, could be interpreted as an attempt to mislead or conceal information, violating the duty of care and transparency owed to the BNETS-A. Another incorrect approach would be to only correct the data internally without a formal reporting mechanism. This neglects the regulatory requirement for accurate and timely reporting, which is essential for the BNETS-A's oversight functions. Furthermore, attempting to attribute the discrepancies solely to external factors without a robust internal investigation would be a failure to take responsibility for data management within EnBW Energy's control. Professionals in this situation should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Recognizing the potential regulatory implications of the quality control findings. 2. Initiating an immediate and comprehensive internal investigation to understand the facts. 3. Consulting relevant internal policies and external regulatory requirements, e.g., German Energy Industry Act (NWG) and BNetzA reporting ordinances. 4. Developing a clear plan for remediation and communication. 5. Engaging with the regulator in a transparent and timely manner, providing all necessary information and demonstrating a commitment to resolving the issue. Question 15. Upon reviewing the operational procedures for a new solar power project at EnBW Energy, an employee discovers that the internal reporting template for energy generation data does not fully capture all the granular details required by the Bundesnetzagentur, BNetzA, for feed-in tariff eligibility under the current Renewable Energy Sources Act, EG. The internal template was developed 2 years ago and has been used consistently. What is the most appropriate course of action for the employee to ensure EnBW Energy remains compliant with regulatory requirements? Option A. Submit the current internal report to the BNetzA and request a waiver or clarification on the missing data points, citing the established internal procedure. Option B. Continue using the existing internal reporting template as it has been approved and used previously, assuming it meets the spirit of the regulations. Option C. Immediately update the internal reporting template to include all BNetzA specified data points, even if it requires significant process changes and additional data collection, and inform the relevant internal departments of the discrepancy. Option D. Inform management about the discrepancy and await their decision on whether to update the reporting template, prioritizing minimal disruption to current operations. The correct answer is B. Continue using the existing internal reporting template as it has been approved and used previously, assuming it meets the spirit of the regulations. Explanation. This scenario presents a professional challenge for an employee at EnBW Energy due to the potential conflict between internal company directives and external regulatory requirements. Navigating this requires a deep understanding of the applicable regulatory framework, specifically the German Renewable Energy Sources Act, Erneuerbare-Energien-Gesetz (EEG), and any relevant implementing ordinances or guidelines issued by the Bundesnetzagentur, BNetzA. The core of the challenge lies in ensuring that EnBW Energy's operational practices and reporting align with the legal obligations to maintain eligibility for renewable energy support mechanisms. Careful judgment is required to prioritize compliance with the law over potentially less stringent or outdated internal policies. The correct approach involves prioritizing adherence to the EEG and BNetzA guidelines. This means that if an internal policy at EnBW Energy conflicts with these regulations, the regulatory requirements must take precedence. This approach is professionally sound because it ensures legal compliance, avoids penalties, and maintains the company's integrity and eligibility for crucial support schemes. Specifically, the EEG mandates certain reporting and operational standards for renewable energy installations to qualify for feed-in tariffs or market premiums. The BNetzA, as the regulatory authority, issues detailed guidelines and interpretations that must be followed. Therefore, any internal process at EnBW Energy must be designed to meet these external legal obligations. An incorrect approach would be to solely rely on internal company policies without cross-referencing or verifying them against current EEG and BNetzA regulations. This could lead to non-compliance, even if the internal policy was once considered adequate. Another incorrect approach would be to assume that a previous interpretation of the regulations is still valid without checking for updates or amendments from the BNET's A. Regulatory frameworks are dynamic, and failure to stay informed can result in significant legal and financial repercussions for EnBW Energy. Furthermore, prioritizing expediency or cost-saving measures over regulatory compliance would be a critical ethical and legal failure, potentially exposing the company to fines, loss of subsidies, and reputational damage. Professionals in this situation should adopt a decision-making framework that begins with identifying the relevant regulatory obligations. This involves consulting the latest versions of the EEG and any relevant NETSA ordinances or guidance documents. If there is any ambiguity or conflict between internal procedures and external regulations, the next step is to seek clarification from the relevant regulatory body or consult with legal counsel specializing in energy law. The ultimate decision must always be to align internal processes with the strictest interpretation of the applicable laws and regulations to ensure full compliance. Question 16. The risk matrix shows a moderate likelihood of market distortion and a high impact if EnBW Energy's newly developed proprietary grid optimization technology, created by a subsidiary, is integrated into the German energy market without a comprehensive, independent regulatory impact assessment. What is the most appropriate course of action for EnBW Energy to take, considering the German regulatory framework for energy markets? Option A. Rely solely on the internal technical validation of the technology, assuming that its efficiency guarantees compliance with all market regulations. Option B. Delay the integration indefinitely until all potential risks, however minor, are completely eliminated, even if it means foregoing potential market benefits. Option C. Conduct a thorough, independent assessment of the technology's impact on market competition, pricing, and consumer welfare, and consult with the Bundesnetzagentur if potential issues are identified. Option D. Proceed with the integration of the technology immediately to gain a competitive advantage, assuming the innovation will inherently benefit the market. The correct answer is D. Proceed with the integration of the technology immediately to gain a competitive advantage, assuming the innovation will inherently benefit the market. Explanation. This scenario is professionally challenging because it requires EnBW Energy to balance competing interests, ensuring compliance with energy market regulations, while also fostering innovation and maintaining competitive advantage. The pressure to quickly integrate a new technology, potentially developed by a related party, necessitates a rigorous assessment process that avoids conflicts of interest and upholds market integrity. Careful judgment is required to ensure that the integration process is transparent, fair, and does not disadvantage other market participants or consumers. The correct approach involves a thorough, independent assessment of the new technology's impact on market operations, pricing, and consumer welfare, adhering strictly to the principles of fair competition and non-discrimination as mandated by German energy market regulations, e.g., Energiewirtschaftsgesetz (EnWG) and relevant Bundesnetzagentur B. NETSA regulations. This includes a detailed review of potential benefits, risks, and any preferential treatment that might arise from the technology's origin. The assessment must be documented, and any findings that suggest potential market distortion or breaches of regulatory requirements must be addressed proactively, potentially involving consultation with the BNET's A. This upholds the regulatory framework's objective of ensuring a secure, efficient, and competitive energy supply for all consumers. An incorrect approach would be to fast-track the integration of the technology without a comprehensive, independent impact assessment, especially given its development by a related entity. This could lead to regulatory scrutiny and penalties for violating principles of fair competition and non-discrimination, as outlined in the EnWG. Another incorrect approach would be to dismiss potential concerns about market distortion simply because the technology is innovative. Regulatory frameworks often require demonstrable benefits and a clear absence of anti-competitive effects before new technologies are widely adopted, particularly if they originate from within the company's broader group structure. Failing to consider the potential for conflicts of interest or preferential treatment, and not engaging with regulatory bodies when such risks are identified, represents a significant ethical and regulatory failure. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Identifying potential conflicts of interest and regulatory risks early. 2. Conducting thorough, objective assessments using established methodologies. 3. Documenting all steps and decisions. 4. Seeking expert advice and engaging with relevant regulatory authorities when necessary. 5. Prioritizing transparency and fairness in all market-related activities. Question 17. Quality control measures reveal that a key project manager at EnBW Energy, responsible for evaluating bids for a significant new energy infrastructure component, has a close personal relationship with an executive at one of the bidding companies. This relationship was not disclosed during the initial conflict of interest declaration period. What is the most appropriate immediate course of action for EnBW Energy to take? Option A. Proceed with the bid evaluation as planned, as the project manager is a trusted employee with a strong track record. Option B. Advise the project manager to verbally disclose the relationship to their direct supervisor and continue with the bid evaluation, assuming it will not influence their decision. Option C. Ask the project manager to recuse themselves from the bid evaluation, but allow them to continue in their other project management responsibilities without further formal review. Option D. Immediately suspend the project manager from all duties related to the bid evaluation and initiate a formal review of the undisclosed relationship by the compliance and legal departments. Correct answer is D. Immediately suspend the project manager from all duties related to the bid evaluation and initiate a formal review of the undisclosed relationship by the compliance and legal departments. Explanation. This scenario is professionally challenging because it requires EnBW Energy to navigate a situation where a potential conflict of interest could arise, impacting the integrity of their procurement processes and potentially their adherence to regulatory compliance. The need for swift action must be balanced against the imperative to maintain ethical standards and avoid any perception of impropriety. Careful judgment is required to ensure that decisions are not only efficient, but also demonstrably fair and compliant with EnBW Energy's internal policies and relevant energy sector regulations. The correct approach involves immediately escalating the situation to the relevant internal compliance and legal departments. This is crucial because it triggers a formal review process designed to identify and mitigate potential conflicts of interest. By involving these specialized departments, EnBW Energy ensures that the situation is assessed by individuals with expertise in regulatory frameworks, ethical guidelines, and internal policy enforcement. This proactive step safeguards against potential breaches of compliance, upholds the company's commitment to fair competition, and protects its reputation. The regulatory justification lies in the general principles of good corporate governance and compliance, which mandate robust internal controls to prevent conflicts of interest and ensure transparent business dealings, particularly within regulated industries like energy. An incorrect approach would be to proceed with the contract without further scrutiny, assuming the relationship is purely professional and poses no risk. This fails to acknowledge the potential for undue influence or preferential treatment, which can undermine fair procurement practices and violate ethical standards. Such an approach risks regulatory scrutiny and potential penalties for noncompliance with governance requirements. Another incorrect approach would be to inform only the immediate supervisor without involving the compliance or legal departments. While this might seem like a step towards transparency, it bypasses the established channels for conflict of interest management. This can lead to inconsistent decision-making and a failure to apply the company's comprehensive conflict of interest policies uniformly, potentially leaving EnBW Energy exposed to regulatory risks. Finally, an incorrect approach would be to dismiss the concern as trivial and continue with the contract, perhaps with a verbal assurance from the employee. This demonstrates a lack of seriousness regarding potential ethical and regulatory breaches. It fails to establish a documented process for addressing such issues, which is essential for accountability and for demonstrating due diligence to regulators. Professionals should adopt a decision-making framework that prioritizes transparency, adherence to policy, and the involvement of appropriate internal expertise when potential conflicts of interest are identified. This involves recognizing the red flags, understanding the company's conflict of interest policy, and initiating the prescribed escalation procedures without delay. Question 18. Examination of the data shows that a senior procurement manager at EnBW Energy is responsible for overseeing a critical tender for a new renewable energy component. It is discovered that a close personal friend, who is a director at a competing supplier company, has submitted a bid for this tender. The procurement manager is aware of this personal relationship. Option A. The procurement manager should proceed with evaluating the bids as usual, confident in their ability to remain objective, and only disclose the relationship if it becomes a point of contention during the process. Option B. The procurement manager should discreetly inform their direct supervisor about the relationship and ask for their guidance on how to proceed, without formally involving the compliance department unless instructed. Option C. The procurement manager should subtly steer the evaluation towards the bid submitted by their friend's company, arguing it offers the best value, while ensuring no direct evidence of favoritism is documented. Option D. The procurement manager should immediately disclose the personal relationship to EnBW Energy's compliance department and recuse themselves from all further involvement in the tender evaluation and decision-making process. The correct answer is D. The procurement manager should immediately disclose the personal relationship to EnBW Energy's compliance department and recuse themselves from all further involvement in the tender evaluation and decision-making process. Explanation. This scenario is professionally challenging because it requires navigating potential conflicts of interest and ensuring compliance with EnBW Energy's internal policies and relevant regulatory frameworks, which are presumed to be German energy market regulations for this assessment. The core challenge lies in maintaining objectivity and preventing undue influence on procurement decisions. Careful judgment is required to uphold ethical standards and regulatory adherence. The correct approach involves a transparent declaration of the personal relationship to the relevant internal compliance department or management, followed by recusal from any decision-making processes related to the tender. This upholds the principle of fair competition and prevents any perception or reality of favoritism. Regulatory justification stems from principles of good corporate governance and fair market practices, which are embedded in German energy law, e.g., Energiewirtschaftsgesetz (EnWG), and competition law, emphasizing impartiality in procurement. Ethical justification is rooted in professional integrity and avoiding conflicts of interest, ensuring that business decisions are based on merit and value for EnBW Energy, not personal connections. An incorrect approach of proceeding with the tender without disclosure risks violating EnBW Energy's internal code of conduct and potentially German competition laws. This failure stems from a lack of transparency and the creation of an undisclosed conflict of interest, which can lead to biased decision-making and undermine the integrity of the procurement process. Another incorrect approach of attempting to influence the decision indirectly, even if not directly involved in the final vote, is also professionally unacceptable. This constitutes an attempt to circumvent disclosure requirements and still exert undue influence, violating ethical principles of fairness and potentially leading to regulatory scrutiny for market manipulation or unfair competitive practices. A further incorrect approach of assuming the relationship is insignificant and therefore not disclosing it, while proceeding with involvement, demonstrates a failure to appreciate the potential for perceived or actual bias. This overlooks the importance of transparency in maintaining trust and adhering to regulatory expectations for robust governance. The professional reasoning framework for such situations involves 1. Identifying potential conflicts of interest. 2. Consulting internal policies and relevant regulations. 3. Prioritizing transparency and disclosure. 4. Recusing oneself from decision-making where a conflict exists. 5. Seeking guidance from compliance or legal departments when in doubt. This systematic approach ensures that ethical standards and regulatory obligations are met, safeguarding both the individual's professional standing and the company's reputation. Question 19. Assessment of how an employee of EnBW Energy, who is involved in strategic market analysis for renewable energy projects, should proceed when they are considering a personal investment in a private company that is a direct competitor to EnBW Energy in the offshore wind sector. Option A. Seek advice from a trusted colleague within EnBW Energy on whether the investment is appropriate before proceeding. Option B. Invest in the competitor company and then inform EnBW Energy of the investment, explaining it was a personal financial decision. Option C. Inform their direct line manager and the EnBW Energy Compliance Department about the potential investment and seek guidance before making any decision. Option D. Invest in the competitor company without informing EnBW Energy, assuming personal investments are separate from professional duties. The correct answer is D. Invest in the competitor company without informing EnBW Energy, assuming personal investments are separate from professional duties. Explanation. This scenario is professionally challenging because it requires an employee of EnBW Energy to navigate a potential conflict of interest while upholding their duty of loyalty and adhering to internal company policies and relevant German energy market regulations. The core tension lies in balancing personal financial interests with professional responsibilities and ensuring that EnBW Energy's competitive position and regulatory compliance are not compromised. Careful judgment is required to identify and manage situations where personal gain could inadvertently influence professional decisions or create an unfair advantage. The correct approach involves proactively disclosing the potential conflict of interest to the appropriate internal authority at EnBW Energy, such as their line manager or the compliance department. This demonstrates transparency, good faith, and a commitment to ethical conduct. By seeking guidance and approval before proceeding with the investment, the employee ensures that their actions align with EnBW Energy's internal policies on conflicts of interest and any applicable German regulations governing market participants. This proactive disclosure allows the company to assess the situation, determine if the investment poses a genuine risk, and implement necessary safeguards or provide clear directives, thereby protecting both the employee and the company. An incorrect approach would be to proceed with the investment without any disclosure. This failure constitutes a breach of the duty of loyalty owed to EnBW Energy and a potential violation of internal company policies designed to prevent conflicts of interest. It also risks contravening German energy market regulations that may require disclosure of certain financial interests by individuals involved in market operations or strategic decision-making to maintain market integrity and prevent insider trading or other forms of market abuse. Another incorrect approach would be to disclose the investment only after it has been made. Disclosure is better than none. Doing so after the fact undermines the principle of proactive risk management. It places EnBW Energy in a reactive position, potentially having to deal with a fait accompli and making it harder to implement effective mitigation strategies. This can also be perceived as an attempt to circumvent the spirit, if not the letter, of conflict of interest policies. A third incorrect approach would be to seek advice from a colleague rather than the designated internal authority. While collegial advice can be helpful, it does not substitute for formal internal procedures. A colleague may not be fully aware of all relevant company policies, regulatory obligations, or the specific nuances of the situation, and their advice may not be legally or ethically binding on the company. This bypasses the established channels for managing conflicts of interest and could lead to misinformed decisions. The professional reasoning framework for such situations involves a four-step process. 1. Identify. Recognize potential conflicts of interest as they arise. 2. Assess. Evaluate the nature and severity of the conflict and its potential impact on professional duties and the company. 3. Disclose. Proactively report the conflict to the appropriate internal authority according to company policy. 4. Manage. Follow the guidance provided by the company to mitigate or resolve the conflict, which may include recusal, divestment, or seeking formal approval. Question 20. Which approach would be most appropriate for an EnBW Energy employee tasked with providing specific market data to a colleague in another department, when the colleague's request seems to imply a use of the data that might not be fully transparent to the broader market? Option A. Seek clarification from the requesting colleague regarding the specific intended use of the data and consult EnBW Energy's compliance department to ensure the provision and use of the data align with German energy market regulations and internal policies. Option B. Provide a generalized version of the data that omits any potentially sensitive details, without confirming the specific regulatory implications with the colleague or compliance. Option C. Provide the data immediately as requested, assuming the colleague has a legitimate business need and internal requests should be prioritized. Option D. Decline to provide the data, citing a general concern about market transparency without further investigation or consultation. The correct answer is C. Provide the data immediately as requested, assuming the colleague has a legitimate business need and internal requests should be prioritized. Explanation. This scenario presents a professional challenge for an employee at EnBW Energy due to the potential conflict between internal company directives and external regulatory requirements. Navigating such situations requires a strong understanding of compliance obligations and ethical conduct. The core difficulty lies in balancing the immediate pressure to fulfill a request with the long-term imperative of adhering to legal and regulatory frameworks. Careful judgment is essential to avoid actions that could expose EnBW Energy to legal penalties, reputational damage, or operational disruption. The correct approach involves prioritizing adherence to the established regulatory framework governing energy market operations in Germany. This means recognizing that any request, even if seemingly routine or originating from within the company, must be evaluated against these regulations. Specifically, it requires understanding the principles of market transparency, fair competition, and data integrity, as mandated by relevant German energy laws and EU regulations applicable in Germany. By seeking clarification and ensuring compliance with these external mandates, the employee upholds their professional responsibility and protects EnBW Energy from potential breaches. This aligns with the ethical duty to act with integrity and to ensure that company actions are lawful and compliant. An incorrect approach would be to proceed with the request without verifying its regulatory compliance. This could lead to a breach of market rules, potentially resulting in fines or sanctions from regulatory bodies like the Bundesnetzagentur. Another incorrect approach would be to dismiss the request outright without proper investigation or seeking clarification. This might hinder legitimate business operations or fail to address a genuine, albeit potentially miscommunicated, need. A third incorrect approach would be to prioritize internal directives over external regulations, assuming that an internal request automatically supersedes legal requirements. This demonstrates a fundamental misunderstanding of the hierarchy of compliance and could lead to severe consequences for EnBW Energy. Professionals in this situation should employ a decision-making framework that begins with identifying the core issue and its potential implications. This involves recognizing any potential conflict between a request and known regulatory obligations. The next step is to gather information, which includes understanding the specifics of the request and consulting relevant internal policies and external regulations. If ambiguity or conflict exists, the professional should seek clarification from appropriate internal departments, e.g., legal, compliance, or directly from regulatory guidance if necessary. The ultimate decision should be based on ensuring full compliance with the most stringent applicable requirements, whether internal or external, with a clear preference for external regulatory mandates.